Hi, and welcome to the Law Simplified. I'm Shraveen Bandaranaike. If you are studying law, chances are that either you're doing it on your own via distance learning, or you might be studying for your LLB, GDL, or even your LLM through a university, which means you have the opportunity of being taught by professors and lecturers in terms of different topics and subjects that you are covering in your qualification. But when it comes to any law degree, what we need to understand is that there are fundamentally two specific components of any qualification, which is the LLB, GDL, or even an LLM. On the one hand, you have the black letter law, or the principles of any given subject. So for example, this will relate to the fundamentals or the principles of that particular subject, which includes statutory provisions and so on. And on the other hand, you have the case law that is substantively needed in order to essentially look at the principles and understand the law by and large. When it comes to students feeling overwhelmed, it's this secondary component that I often get asked questions on. You'll encounter perhaps hundreds of case law in relation to any given subject, and this tends to overwhelm specifically a student in the first year coming into any particular qualification. This is normal by and large. It's just across the board something that every single student goes through. But fundamentally, when you look at any qualification, these are the two aspects that even in a university context, your professor or your lecturer would essentially outline and showcase to you as what needs to be studied. More often than not, the lecturer or the professor himself would be going through this substantive material. Having gone through it multiple times himself, it's quite common to him in terms of how he articulates and presents it to you. However, there is one fundamental component apart from these two aspects, the substantive black letter law and the case law, that is essential to elevating your understanding of the law and, more importantly, your performance in an examination. Now, this is something, on the one hand, that you yourself might not be able to figure out if you are studying via distance learning, and more often than not, professors and lecturers don't specify to a student. This is by no fault of them, it's just the structure of a university does not provide a conducive environment to do so. So this one fundamental thing that no one tells you is that the bridging agent, something that will elevate your responses and your understanding of the law, is you. What I often see, or rather what I lack seeing in terms of the responses that I get from my masterclass as well as some of the Udemy students that have approached me, and I see this consistently, is that I don't see the student in the response. In other words, it's very rare that I see the voice of the student within their examination responses. Now, this is something that needs to be inculcated at the very inception of your qualification. Just learning the law, the substantive content that's presented in perhaps your textbooks or your subject guides is insufficient. Similarly, knowing A to Z or verbatim the terminologies, the ratio, and the facts of cases is also insufficient, because all of those things will just help you explain the law. It doesn't help you articulate and argue the principles. Quite often, if you've gone through examination questions, for instance, you'll notice that they are based around three fundamental instructions or directions. I've done a separate video on it, which I will link in the description below, as well as you'll be able to see in the pop-out banner on the top right there. Essentially, most questions are aimed at either advise, critically assess, or discuss. Whichever way it is formulated, it expects you to argue and articulate a particular stance. This cannot be done by just learning the substantive law nor the case law. It needs to have substantive conviction of response. In other words, your voice. It needs to have your opinion and your argument. This is what's quite often lacking because it's neither communicated to you in a university context nor could you figure it out on your own. This was a very quick video because I tend to see this as a pattern, having gone through hundreds of feedback reports over the past examination season, and it's one of the feedback responses that I usually give to my students as well. It's something that is part and parcel of the articulation component in the feedback reports that I provide, that it's very rare that I see the voice of the student. I know that the knowledge is there, I know that there's an understanding of the law to a certain degree, but it doesn't go beyond that. I don't see argument, I do not see fundamental conviction of response. So this is something that I see across the board, and something that you should think about the next time that you answer responses and study each individual topic of any given subject in law. Thanks a lot for watching this video. If it was helpful, make sure you give a thumbs up. Subscribe to the Law Simplified channel. I upload weekly videos of this nature to help you with your technique, and I guide you through the processes and the nuances of the law. But until the next time that we meet, have fun, stay safe, and obey the law.